I welcome you in my 9th lecture regarding legal compliance for incorporating startup. And I am in the module of incorporation of partnership, LLP and cooperatives. And in this present lecture, I will concentrate more on law relating to cooperatives. Now, I believe I have introduced this particular concept of cooperatives as a business form in my introductory lectures. And I told you that cooperatives is one of the association of person, is a flexible organization, but having some sort of formal setup. So, when we talk about the cooperatives, it is more formal than a partnership, but it is less flexible, or it is a flexible than that of a company. Now, at the same time, in case of the cooperatives, there is a kind of a the element which indicates about the social service. That means, whenever you are talking about the cooperatives, it should have some kind of objective which will promote the interest of the group who are promoting this particular cooperatives, or it will ultimately help to the society at large. But cooperative can be used for the purpose of startup also, because if you are in technology, if you are wanted to promote a technology startup, and in that particular technology startup you have objective of solving some of the societal issues, then cooperative can be one of the business form for you, because it gives you a flexibility. Cooperatives somewhere give you a less cost relating to the compliance. At the sometimes you can carry forward your objective the way you wanted to go ahead in your startup, and it also give you the opportunity to scale it up, because you can finance your cooperative from the public financial institutions, and some of the state government do provide financial backup for the cooperatives, or encouraged to incorporate the business through the cooperatives. Now, I have discussed this particular point with you previously, that the cooperatives are governed by the different state cooperative laws. That means, every state have their own cooperative laws, and somewhere they have some kind of a benchmarking, that means a similarity between all these particular cooperatives law, but they are not same. So, some state government law might add some additional provision which you might not find in other cooperative laws. Now, at the same time, I have given the example here is the West Bengal Cooperative Society Act 2006. It is a further amended and consolidated act which has been now in force, but at the same time you will find the Cooperative Act is not this new. It is basically age old, it is quite old, and the system of the cooperatives basically we get from the European legal system. So, I am not going to go into the origin and all this particular thing, but for your information, let me tell you, cooperatives is give you kind of a flexibility which the member might look for in promoting the business or the research, or some kind of a social innovation, or participate in social problem solving, and so much so forth. Now, the affair of the cooperatives should be managed by the person who are elected and appointed by the members, and generally you will find the members are elect themselves in the management position, or which we call a board of directors. But in generally the power of managing the cooperatives is lied with the general body, which I am going to discuss with you. Now, member holding the share capital shall only receive strictly limited compensation by way of dividend. So, what it indicates that cooperatives is not actually for money making or profit distribution organization, but it is more of promoting the interest of the society or the members or the society members belong. So, it that is the reason I said that it is kind of a social organization. I am going to talk further as I will go ahead, that there is some kind of a restriction which is also provided relating to the holding of amount of holding of shares which you can hold or amount of shares which you can hold in these particular cooperatives. Now, I have given up principles. These particular principles in generally followed by the cooperatives which is incorporated in different states, and if you look into this particular principle, it says that it works like a self help group and controlled by the member, and then it says that they can raise the capital from the external sources. So, in case of the partnership, as I have said, that there is a kind of a limitation that the partner has to bring the capital in that particular organization, but herein it is not so. You can even access the external capital. At the same time, you can also access the state finances, and at the same time it talks about the self help group. That means those people who are the member of this particular organization, they are supposed to run the administration. And at the same time, as I was talking about, that it should have kind of agreement amongst the members themselves, that how they are going to run this particular organization, because this particular organization also called that it is a democratically controlled by their member, democratically controlled by this their member. Now, cooperatives are also concerned relating to the communities where they are working. That is what I said, that there should be some kind of a social element, or they should be used for benefiting the society, and no other person than a cooperative society shall use the name cooperative society in their trade name. So, there is a kind of a bar of using the word cooperatives in the trade name itself, if that particular society is not a cooperative society. Now, cooperative society, I have talked with you, generally established with a social objective, and it can be with a limited and unlimited liability. Now, if it is a unlimited liability, then in that case that has to be specifically provided in the society's bylaw, which I am going to discuss in my next lecture in detail. And in those particular circumstances, the member of the society will have several joint and several liability for the debt which is incurred by these cooperatives during the course of the business. But if it is the limited liability, then in that case it is actually governed by whatever has been promised in that particular bylaws, or whatever the provision has been provided in the bylaws. In generally, it limited to the extent of the capital contribution, but there can be a further more than that also. That means, in addition to the capital contribution, you might ask for something more to be taken care by the member of this particular society. So, it is governed by whatever you have provided in the bylaws of that cooperatives. Now, cooperatives is a body corporate. So, once it is a body corporate, it has a consequential issues, like it can have his own seal, then it can have a perpetual succession, it can acquire the property, it can be sue and sue. That means, which I have discussed even when I was talking with you LLP, that they have basically attribute like a natural person. This is a bit of a legal connotation, but you can understand this, that whatever the property which the cooperatives are acquiring, it is acquiring in the name of the cooperatives, unlike a partnership. In case of the partnership, what I said, that it is a joint property of partners and the firm, but in case of the cooperatives, it is a property of the cooperative. So, member cannot say that this is my property, but member can get the benefit out of that particular property, or they can use that particular property for a particular purpose for which this particular cooperative has been promoted. Now, in case of the cooperatives, who can be the member? In generally, the individual who is competent to enter into contract can be a member. Then other cooperative society can be a member. Then you will find the state government can be a member, and self help group can be a member. Even the financial bank can be a member. So, many of the time you will find the cooperatives is incorporated for several purposes. Now, I'm talking with you using the cooperative for purpose of promoting the startup, but you will find the cooperatives used for financing the local ventures, like cooperative banks. You will find at the same time you will find the state government is promoting the cooperatives for development of a particular group of people, like for the farmers, they can promote a cooperatives which can sell the fertilizers or the agriculture equipment and all these things. In other cases, like other cooperative society further can they have promote the another cooperatives, or they can have a number of subsidiaries under them, they themselves only, or at the same time even individual can promote these particular cooperatives. So, in case of the cooperatives, there can be a multi-layer structure. That means there can be holding cooperatives. At the same time, under that particular cooperatives, there is a number of subsidiaries which has been promoted by that particular holding cooperatives. But at the same time, you should keep in the mind, in case of the cooperatives, there can be some member who might not share the profit, at the same time who might not able to vote. Like employee of a cooperatives can be a member. At the same time, some other cooperatives who have promoted this particular cooperative, or who is somehow related to this particular cooperative, can be a member of that particular cooperative itself. Or say for example, a student who is participating, who is studying in an institute which is run by a cooperative, he can be a member of that particular cooperatives. So, these particular member cannot be a member of the board, and they cannot also have a financial interest or cannot share the profit in that particular cooperatives. Now, there can be a criteria relating to the admission as a member, and the law generally provide that in what circumstances the and what are the procedure one need to follow relating to the member. Like in ordinarily, if there is a no specific reason or compelling reason, you cannot refuse any person to be a member of that particular cooperative, where that particular person meet the interest of the cooperative. And they can also provide the timeline within which the cooperatives board has to take a decision, or the general body of the cooperatives has to take a decision that that particular person can be given the membership. And sometimes even the law prescribe that if you are not given the membership within a specific date, then in that case by default that particular person who has applied for the membership will be a member. Like sometimes it prescribes 60 days, sometimes it prescribes 90 days, so much so forth. Now, the member has a right to vote. Every member of the cooperatives can have a one vote, and the society, every member of a cooperative society can cast vote in person. Now, if the cooperative is a member of another cooperative, then in that case there will be authorized person who can vote it, or where the membership is a joint, that means one membership is held by 2%, then in absence of one member, another member can cast the vote if he is authorized to do so. Now, when I am talking about casting the vote, I am basically talking about casting the vote in the general meeting, which I am going to discuss a little later. Now, I have talked with you relating to the liabilities, that is unlimited liabilities and limited liabilities, and whatever the liabilities you are taking in that particular cooperatives, you need to put it clearly in your bylaws. Now, there can be a restriction on holding of the shares by the members, like if the law might specify that a single member cannot hold more than 1/5 of the total shares of the cooperatives. So, that kind of restriction can be imposed, because I told you before also that cooperative cannot be used as a profit making vehicle. Cooperatives are generally used for the purpose of social good, or for promoting the social cause, or promoting the interest of a particular community. Now, there can be restrictions in the transfer of the shares, and there can be several conditions which may specify then in which circumstances the share can be transferred. Now, there can be a provision relating to the disposal of the members, deceased members' right in that particular cooperatives. In generally, if there is a nominee is mentioned in the membership of the cooperatives, then nominee has given all the benefit which the deceased member otherwise entitled to. In other cases, the legal heirs can get this particular benefit, or in the circumstances where they are not traceable, neither nominee or any legal member is traceable, then in that case the bylaws might provide some kind of provision for disposing of the deceased member shares of the in the cooperatives. Now, the management of the cooperatives is generally happen in two layers. One layer is known as the general body of the cooperatives, and the second layer is known as board of directors. And the general body of the cooperative society is basically hold the entire authority. That means it is a final authority who will decide about any matter of the cooperatives. So, to put it in another way around, the residual power which has not been delegated to the board is lying with the general body. So, general body can take a decision, even amendment of the bylaws, to rustication of the member, to restructuring of the cooperatives, to amalgamate the cooperatives, to spin off the cooperatives, to start a subsidiary of a cooperatives. So, any matter relating to the change of organization, any matter relating to the finance, any matter relating to the management of the cooperatives can be taken by the general meeting, and I am going to talk more detail in my next lecture on these. Now, you need to have a general meeting, a annual meeting of the general body, and the law, several laws specify in several manner. Sometimes even the law specify that in which of the month you need to hold the first meeting, in which month you need to hold the second meeting, third and fourth meeting. Sometimes law specifies that you have to hold the meeting in every quarters, or sometimes there might be a prescription of a more number of the meeting of this particular general body. And whenever the general body is meeting, there is a specific agenda which need to be placed before the general body to decide issues. Now, the agenda here I have listed down. This is more based on the West Bengal Cooperative Society Act, and therein you will find, but it is more of a generic in nature. So, you will find most of this particular provision in almost all the cooperatives. There might be some kind of a variation into this particular thing. Now, the agenda of the general meeting may include the matter relating to the election of the director, then confirmation of the proceeding of the last half yearly and annual general meeting and special general meeting. Then it can talk about the consideration of annual report which has been submitted by the board. It need to consider the audit report, then it need to consider the annual budget, and then if you wanted to make any inquiry or inspection relating to the affair of the cooperatives, then in that case it can be considered by the annual general meeting also. Now, they also further consider relating to matter relating to loan and advances which is given to the directors or their relatives, and how they have been recovered, or what are the procedure have been followed to recover, or that particular loan has been at all recovered or not. Now, they can also talk about the appointment of the director, and what are the process they need to follow, or they can elect these particular directors who are going to run the day-to-day activity of these particular cooperatives. Then they can talk about creation of a specific reserves. Now, these reserves is a very interesting thing. Reserve means you are keeping aside some of the profit which you are making during the business of the cooperatives, and these particular reserves can be utilized in the future by the cooperatives for the different purposes. Either they can earmark this particular purposes in the general meeting, or they can simply keep it open, and whenever it is required they can utilize this particular reserves. Now, if the cooperatives has a good reserves, then cooperatives has a better credit worthiness, and the cooperative might have a very strong market share or market capitalization. Now, you need to talk about in the general meeting relating to the distribution of net profit. Then you need to talk about the operation deficit which if you have, and you have to make plan for that particular operation deficit. Then you need to talk about approval of a long term prospective plan and operation plan, and you can decide about the plan maybe for 5 years, maybe for 10 years, which can be the broad guiding principle for your smaller plan of every years. So, you can fix the target, and you can accordingly further develop your plan how to go ahead in the future. Then you can talk about the fixation of the borrowing limit if it is necessary from outsider. Then you can talk about the code of conduct of the members or the member of the board, how they should behave into that particular organization. Then if there can be amendment of laws in the general meeting, expulsion of the member. That means you can take a decision to expel a particular member, and it should be according to the bylaws which has been specified. Then in what circumstances you should take a decision to expel a member. And then you can consider any other matter which has been specified by the bylaws, and there may be a miscellaneous item in the general meeting itself. So, what you can find in the general meeting, that anything which is relating to the operation and the constitution and the capital and the membership or anything relating to the bylaws of the organization can be decided. Now, in case of cooperatives, the important thing is that you can transfer, divide and amalgamate. All this thing is possible, and many of the time you can transfer wholly in part of his business and the liabilities to other cooperatives, or you can divide a particular cooperatives into two cooperatives. That means you can split the cooperatives and you can divide the rights and liabilities of these particular cooperatives. Or if you think that the cooperatives have created an independent business, and which is for the better administration, it need to be divided and it need to be split, then in that case you can do that. Sometimes it might so happen that there is a stress cooperatives, or there is a weak cooperatives, or there is a financially unsound cooperatives, and that particular cooperatives need to be taken over or need to be amalgamated with the strong cooperatives. That also can be done. You can also think of merging or amalgamating number of cooperatives together for a better operation. So, all this reorganization is possible as we talk in case of incorporated body, like I have talked with you in case of the LLP. It can be done in case of the companies, and similarly it can be done in case of the cooperatives too. Cooperatives, as I have told you, that there can be a reorganization possible, and this particular reorganization can be based on the strategic reason, based on the development, based on better market access, based on better benefit given to the members of the companies, so much so forth. So, you can take this particular decision based on certain criteria relating to this. Now, the last one which I wanted to talk with you relating to the dissolution of the cooperatives. In case of a dissolution of the cooperatives, there is a three way you can do that. The first one is based on the report of the inspection. I have talked with you report of the inspection because there might be a situation where the affair of the cooperatives are not carrying out according to the bylaws or the laws of the cooperative, and they can give a report. It can be relating to malpractice by those member or some of the member who are in charge of the management, or it might be relating to the financial issues, or it might be relating to other aspect or which has come out because in this particular investigation, or it might be relating to the instance of any board member or the member who has brought some of the information to the registrar, and registrar think that it is a good time to dissolve this particular cooperatives because it is creating otherwise the problem to run this particular organization, or even the registrar can do it by its own motion. Now, whatever the position is, then in that case you need to publish the dissolution of the cooperatives, and this particular notice should go to the public domain, and once it is done, then you need to appoint a liquidator. The liquidator is going to liquidate the entire assets of the cooperatives, and it will distribute between the members as well as the creditors into this particular thing. Now, before I leave this particular thing, let me draw your attention. Now, the state government is taking very seriously relating to appointment or appointment of the board in case of the cooperatives. So, some of the state has created the mechanism within the law itself that there will be a body, or the body will be acting under the directors or the registrar of the cooperatives, who will hold or manage the election of the members in the board of the cooperatives. So, whatever the law which is governing to you, you need to check that particular thing, that are you subjected to that particular law or not, and if you show, then in that case you need to govern by, you need to take care about that particular provision. So, this is all about the cooperative law relating to the cooperatives, and there can be some further provision or the variation as you move from one state to another state, and you need to be careful, or you need to take a professional advice for this particular purpose. Thank you.